Letters of credit. What are letters of credit? Any arrangement, however named or described, whereby a bank acting upon the request of its client or in its own behalf agrees to pay another against the stipulated documents provided that the terms of the credits are complied with. What is the duration of letters of credit? Upon the period fixed by the parties, or if none fixed, 6 months from its date if used in the Philippines, 12 months if used abroad. Governing laws. What laws govern commercial transactions? In the absence of any particular provision in the Code of Commerce, commercial transaction shall be governed by the usage and customs generally observed. Is a letter of credit an accessory contract? Letters of credit are in effect an absolute undertaking to pay the money advance or the amount for which credit is given on the faith of the instrument. They are primary obligations and not accessory contracts. Note: a letter of credit by itself does not come into operation without a contract supporting it. It is not a contract that can stand on its own. It needs supporting contract. In a commercial letter of credit, it is a sale. In standby letter of credit, it is a non-sale transaction. Describe the liability of the bank which issued the letter of credit. It is neither a surety nor a guarantor. The liability of the issuing bank is primary and solidary. It is also not entitled to the benefit of execution. What is the purpose of the letters of credit? To ensure certainty of payment. The seller is assured of payment because the bank intervenes and makes the commitment to pay. This addresses problems arising from the seller's refusal to part with his goods before being paid, and the buyer's refusal to part with this money before acquiring the goods, thus facilitating commercial transactions. Note: the issuing bank should pay the beneficiary upon the latter's submission of the stipulated documents and compliance with the terms of the credit, even though there is a pending issue on whether or not the main contract underlying the letter of credit has been paid or fulfilled or not. What are the two kinds of letters of credit? Commercial, standby. Commercial involves contract of sale, payable only upon presentation of the seller beneficiary of documents that show he has performed his contract. Standby involves non-sale transactions, payable upon certification by the beneficiary of the applicant's non-performance of the agreement. What are the other kinds of letters of credit? Irrevocable letter of credit. A letter of credit wherein the terms and the undertakings of the issuing bank cannot be amended or altered or revoked without the consent of the beneficiary. Revocable letter of credit can be amended, altered, or revoked even without the consent of the beneficiary. Confirmed letter of credit. The liability of the confirming bank is primary. Non-confirmed letter of credit. Is irrevocable letter of credit and confirmed letter of credit synonymous? An irrevocable letter of credit is not synonymous with a confirmed letter of credit. In an irrevocable letter of credit, the issuing bank may not, without the consent of the beneficiary and the applicant, revoke its undertaking under the letter, whereas in a confirmed letter of credit, the correspondent bank gives an absolute assurance to the beneficiary that it will undertake the issuing bank's obligation as its own according to the terms and conditions of the credit. Irrevocable letter of credit. The issuing bank may not, without the consent of the beneficiary and the applicant, revoke its undertaking under the letter. Confirmed letter of credit. The correspondent bank gives an absolute assurance to the beneficiary that it will undertake the issuing bank's obligation as its own according to the terms and conditions of the credit. Can the irrevocable nature of letter of credit be changed? The terms of an irrevocable letter of credit cannot be changed without the consent of the parties, particularly the beneficiary thereof. Philippine Virginia Tobacco Administration versus De Los Angeles. Can a court order the release to the applicant the proceeds of an irrevocable letter of credit without the consent of the beneficiary? No. Such order violates the irrevocable nature of the letter of credit. The terms of an irrevocable letter of credit cannot be changed without the consent of the parties, particularly the beneficiary thereof. Parties to a letter of credit. Who are the parties to the letter of credit? Applicant, beneficiary, issuing bank. Who is the applicant? He may be the buyer, importer, or obligor. The person who procures the opening of letter of credit and who agrees to reimburse the issuing bank any and all amounts should be paid under the letter of credit once the issuing bank is compelled to pay because the beneficiary is able to submit the document stipulated. He agrees to pay the bank that issued the letter of credit. The applicant has no obligation to reimburse the issuing bank if the latter pays without the stipulated amounts duly paid under the letter of credit. Who is the beneficiary? The one entitled to payment from the issuing bank upon his submission of the document stipulated in compliance with the terms of the credit. What is the effect of the failure of the beneficiary to fulfill his obligation under the main contract? It does not negate his right to payment from the issuing bank as long as he is able to submit the required documents and comply with the terms of the credit without prejudice to his liability against the account party under the law on contract and damages. Who is the issuing bank? The one that undertakes to pay the beneficiary upon submission of the beneficiary of these stipulated documents in compliance with the terms of the credit. Enumerate the other parties. Advising or notifying bank, not liable to pay the beneficiary. It does not have any contractual relations with the beneficiary. Its only obligation is to determine the apparent authenticity of the letter of credit, to check if at first glance that the same is genuine or valid. If valid, the advising or notifying bank notifies the beneficiary of the letter of credit, transmit the letter of credit in favor of the beneficiary so that the beneficiary can cause shipment to the equipment. Paying bank, an agent of the issuing bank for the purpose of making payment to the beneficiary. He can also be the advising bank. Confirming bank, it lends credence to a letter of credit issued by a lesser known bank as if it is the one who issued the letter of credit. Its obligation is similar to an issuing bank, thus beneficiary may tender documents to the confirming bank and collect payment. Negotiating bank, the bank in the city of the beneficiary which buys or discounts the draft contemplated by the letter of credit, if such draft is to be drawn on the opening bank, not in the city of the beneficiary. Correspondent bank of issuing bank, if the account party is in the Philippines and the beneficiary is abroad, the beneficiary will be notified and consequently be paid through the correspondent bank. Describe the duty of the advising bank. It determines the apparent authenticity of the letter of credit and notifies the beneficiary of the letter of credit. He does not guarantee the genuineness or due execution of the letter of credit. It is not liable for damages, even if it turns out to be spurious, provided the spurious character is not apparent on the face of the instrument. Does the advising bank have the obligation to pay the beneficiary? General rule, no. Exception, when the advising bank is also the confirming or paying bank. 3 distinct relationships arising from a letter of credit. Q. Explain the 3 distinct but intertwined contract relationships that are indispensable in a letter of credit transaction. Between the applicant, buyer, importer, and the beneficiary or seller or exporter, the applicant, buyer, importer is the one who procures the letter of credit, while the beneficiary or seller or exporter is the one who, in compliance with the contract of sale, ships the good to the buyer and delivers the documents of title and draft to the issuing bank to recover payment for the goods. Their relationship is governed by the contract of sale. Number 2, between the issuing bank and the beneficiary or seller or exporter. The issuing bank is the one that issues the letter of credit and undertakes to pay the seller upon receipt of the draft and proper documents of title. On the other hand, the beneficiary, seller or exporter surrenders document of title to the bank in compliance with the terms of the letter of credit. Their relationship is governed by the terms of the letter of credit. Number 3, between the issuing bank and the applicant or buyer or importer. The applicant or buyer, importer, oblige himself to reimburse the issuing bank upon receipt of the document of title. Their relationship is governed by the terms of the application for the issuance of the letter of credit by the bank. Note, these relationships, while interrelated, are distinct and separate from each other. When is the bank entitled to reimbursement? Once the issuing bank shall have paid the beneficiary after the latter's compliance with the terms of the letters of credit. Presentment for acceptance to the customer or applicant is not a condition sine qua non for reimbursement. Is presentment a condition prior to reimbursement? Presentment for acceptance to the customer or applicant of the draft drawn by the beneficiary is not a condition sine qua non for reimbursement. Prudential Bank and Trust Company versus IAC. What is the consequence of payment upon an expired letter of credit? An issuing bank which paid the beneficiary of an expired letter of credit can recover the payment from the applicant which obtained the goods from the beneficiary to prevent unjust enrichment. Should the marginal deposit made by the customer in possession of the bank be first deducted from the principal indebtedness before computing the interest? Yes, since it is supposed to be returned upon compliance with its obligation. Indeed, it would be onerous to compute interest and other charges on the face value of the letter of credit which the issuing bank issued, without first crediting or setting off the marginal deposit which the importer paid to it. Requiring the importer to pay the interest on the entire letter of credit without deducting first his marginal deposit would be a clear case of unjust enrichment by the bank. Note, the applicant has the right to have the marginal deposit deducted from the principal obligation under the letter of credit and to have the interest computed only on the balance and not on the face value thereof. Doctrine of Independence. What is the doctrine of independence? Under this doctrine, the obligation of the issuing bank to pay the beneficiary does not depend on the fulfillment or non-fulfillment of the contract supporting the letter of credit. If it is a commercial letter of credit, the obligation if the issuing bank to pay the beneficiary is not affected by any breach of contract by the seller to the buyer, because the contract between the issuing bank and beneficiary is separate and distinct from the contract between the seller and the buyer. Does the issuing bank have the obligation to determine whether or not the main contract has been fulfilled or not? No. The issuing bank is liable to pay the beneficiary upon the latter's submission of the stipulated documents and compliance with the same of the credit regardless of any breach of contract by the beneficiary to the applicant of the letter of credit. The Supreme Court held that banks deal with documents, they don't deal with goods. The issuing bank has no obligation to check the object, the quantity or quality of the goods. The bank needs not to verify or go beyond the four corners of the document. The issuing bank will determine the documents to be submitted, where the stipulated documents tendered faithfully. If the documents were submitted, the issuing pays the seller. What is the exception to the doctrine of independence? Fraud exception principle. What is the fraud exception principle? The beneficiary may be enjoined from collecting on the letter of credit if the following elements are present. A. There is a fraud on the part of the beneficiary. B. Fraud must be in relation to the independent purpose or character of the credit. C. Unless the beneficiary is restrained, the applicant shall suffer grave and irreparable injury. Note, to be an exception, the fraud must not be in relation to the performance of the main contract, but in relation to the independent purpose or character of the credit. What is the remedy for a fraudulent abuse? Injunction. Doctrine of strict compliance. How should commercial transaction involving letter of credit be complied? Commercial transactions involving letters of credit are governed by the rules on strict compliance. What is the so-called doctrine of strict compliance? The documents that the beneficiary should submit to the issuing bank or confirming bank must strictly conform to the documents stipulated. If there is discrepancy, the issuing bank is not liable to pay. If it pays at its own risk and cannot obtain reimbursement from the applicant. It matters not that the submission of the documents are unfair, unjust, or inequitable. The point is, it requires that the document stipulated must be the document to be submitted. Otherwise, the issuing bank is not liable or the beneficiary is not entitled to payment. Trust receipt. What is a trust receipt transaction? It is any transaction between the entrustor and entrustee whereby the entrustor, who owns or holds absolute title or security interest over certain specified goods, documents, or instrument, releases the same to the possession of entrustee upon the letter's execution of a trust receipt agreement. It is a transaction wherein the entrustee binds himself to hold the designated goods in trust for the entrustor, and in case of default, to sell such goods, documents, or instrument, with the obligation to turn over to the entrustor the proceeds to the extent of the amount owing to it, or to turn over the goods, document, or instrument itself if not sold. Note: to be in the nature of a trust receipt, the entrustor should have financed the acquisition or importation of the goods. The funds should have been delivered before or simultaneously with delivery of the goods. What is a trust receipt? What is a trust receipt? Okay. It is the written or printed document signed by the entrustee in favor of the entrustor, containing terms and conditions substantially complying with the provisions of PD 115. What is the consequence where the execution of the trust receipt agreement was made only after the goods covered by it had been purchased by and delivered to the entrustee, and the latter as a consequence acquired ownership over the goods. In such case, the transaction does not involve a trust receipt, but a simple loan, even though the parties denominated the transaction as one of trust receipt. Colinares versus CA. Consolidated Bank and Trust Corp versus CA. Parties to a trust receipt agreement. Entrustor and trustee. Who is an entrustor? A lender, a financer, or creditor, person holding title over the goods, documents, or instruments, subject to a trust receipt transaction, releases possession of the goods upon execution of trust receipt. Who is an entrustee? A borrower, buyer, importer, or debtor, person to whom the goods are delivered for sale or processing in trust, with the obligation to return the proceeds of sale of the goods or the goods themselves to the entrustor. Letters of credit and trust receipts, not negotiable instrument. Are letter of credits and trust receipt considered as negotiable instrument? No, but draft in connection with the former are negotiable instruments. Two features of a trust receipt agreement: loan feature, security feature. Discuss the dual features of a trust receipt agreement. A trust receipt has a loan and security features. The entrustor or bank extends loan to the entrustee, importer, and retail dealers to finance the importation of goods or instruments in favor of the entrustee, who may not be able to obtain credit except through utilization of the merchandise imported or purchased. The security feature is a covering trust receipt, which secures the indebtedness. Effect of failure on the part of entrustee to comply with its obligation. What is the effect of payment of the loan or delivery of the sale proceeds equivalent to the full amount? It extinguishes both criminal and civil liabilities of the entrustee. Section 13. Penalty Clause. The failure of entrustee to turn over the proceeds of the sale of the goods, documents, or instruments covered by the trust receipt to the extent of the amount owing to the entrustor, or as appears in the trust receipt, or to return said goods, documents, or instruments if they were not sold or disposed of in accordance with the terms of the trust receipt, shall constitute a crime of estafa, punishable under the provisions of Article 315, Paragraph 1, Letter B of Act numbered 3815, as amended, otherwise known as the Revised Penal Code. If the violation of offense is committed by a corporation, partnership, association, or other judicial entities, the penalty provided for in this decree shall be imposed upon the directors, officers, employees, or other officials or persons therein responsible for the offense, without prejudice to the civil liabilities arising from the criminal offense. PD 115 is not violative of the constitutional provision against imprisonment for the non-payment of debt. Is PD 115 violative of the constitutional provision against imprisonment for the non-payment of debt? Why does it keep repeating? No, because what it sought to be penalized is not the non-payment of debt, but the dishonesty and abuse of confidence in the handling of money, or goods to the prejudice of another. It punishes the act, not as offense against property but against public order. People versus Nitafan 207 Squa 726. Note: the penal sanction covers criminal liability, civil liability. Staffa: what is the effect of the failure of the entrustee to deliver the proceeds of the sale of the goods or instruments subject to the trust receipt or return the goods? It will constitute estafa. May the civil action for the collection of the loan be instituted independently of the criminal action? Yes. What is the effect of the acquittal of the entrustee in the criminal case as a result of the surrender or consignation of the goods? The acquittal of the entrustee in the criminal case as a result of the surrender or consignation of the goods is not a bar to the filing of a separate civil action to enforce payment of the loan. Vintola versus Insular Bank of Asia in America. What is the effect of compromise of estafa case arising from trust receipt transaction after the case has been filed in court? Compromise of estafa case arising from trust receipt transaction after the case has been filed in court does not amount to novation and does not erase the criminal liability of the accused. Ong versus CA. Penalty in case of corporation. What is the entrustee? What if the entrustee is a corporation? In such case, the law makes the officer or employees or other persons responsible for the offense liable to suffer the penalty of imprisonment. The criminal liability falls on the human agent responsible for the violation of the trust receipt law. A person who admits being the agent of the entrustee corporation is a person responsible for the offense if he is the signatory of the trust receipts and if he cannot explain why he is not responsible for the failure to turn over the proceeds of the sale or account for the goods covered by the trust receipt. Why are the officers, employees, etc. of a corporation responsible for the offense? It is because they are vested with the authority and responsibility to devise means necessary to ensure compliance with the law, and if they fail to do so, are held criminally accountable. Yet a corporation may be charged and prosecuted for a crime if the impossible penalty is fine. Ching versus Secretary of Justice. Is the person signing the trust receipt for the corporation solidarily liable with the entrustee corporation for the civil liability arising from the criminal offense? No. He may, however, be personally liable if he bound himself to pay that of the corporation under a separate contract of surety or guarantee. Ong versus CA. Can we file a criminal case against the corporation? It depends. If the penalty is imprisonment, we cannot file a criminal case. But if the penalty is a fine or a forfeiture or revocation of the corporation's franchise, then we can. Civil obligation remains as long as loan is not paid. What is the effect of non-payment of the loan? The civil obligation still remains. What is the effect of the loss of the goods subject to the trust receipt? Loss of the goods subject to the trust receipt, regardless of the cost, does not extinguish the civil liability of the entrustee. What is the effect of return of goods? If the loan is not yet paid, the return of the goods may extinguish the criminal liability, but not the civil liability of the entrustee unless the goods are sold and the proceeds thereof applied in full payment of the loan. Penal sanction applies to goods intended for sale only. When thus the penalty sanction under the trust receipts law apply. Jurisprudence provides that the penal sanction does not apply in case the goods are not intended for sale or resale as when they are for actual use. Cases where no criminal liability despite execution of trust receipt agreement. 1. Compliance with the terms of the trust receipt either by payment, return of the proceeds, or return of the goods. 2. The transaction is not a trust receipt within the contemplation of the trust receipt law. 3. Surrender of the goods to the entrustor. 4. Non-delivery of the goods to the entrustee. 5. Compromise agreement before the filing of the criminal information for violation of the trust receipt law. 6. Cancellation of the trust in taking possession of the entrustor. Note: mere repossession of the goods will extinguish criminal liability. 7. Loss of the goods due to force majeure. 8. Consignment. Who is the owner of the articles subject to the trust receipt? The entrustee. A trust receipt has two features, the loan and the security features. The loan is brought about by the fact that the entrustor financed the importation or purchase of the goods under trust receipt. Until and unless this loan is paid, the obligation to pay subsists. If the entrustee is made to appear as the owner, it was but an artificial expedient, more of legal fiction than fact, for if it were really so, it could dispose of the goods in any manner that it wants, which it cannot do. To consider it the entrustee as the true owner from the inception of the transaction would be to disregard the loan feature thereof. Rosario Textile Miles Corporation versus Home Bankers Savings and Trust Company. Can the entrustee mortgage or pledge the articles in trust? The articles covered by the trust receipts are owned by the entrustor, and they were only held by the entrustee in trust. While it was allowed to sell the items, the entrustee had no opportunity to dispose of them or any part thereof or their proceeds through a conditional sale, pledge, or any other means. Accordingly, the entrustee has neither ownership, free disposal, nor the authority to freely dispose of the articles. Hence, the entrustee could not have subjected them to a chattel mortgage. DBP versus Prudential Bank. Note: the entrustee cannot mortgage the goods because one of the requisites of a valid mortgage is that the mortgager must be the absolute owner of the property mortgaged or must have free disposal thereof. Entrustee is not the absolute owner of the goods, nor has the free disposal thereof. Receipt of bank of sum of money without reference to trust receipt obligation. What is the effect of the receipt of the bank of a sum of money without reference to the trust receipt obligation to which the same pertains? It does not obligate the bank to apply the money received against the trust receipt obligation. Does it have the effect of compensation? No, since compensation is not proper when one of the debts consists in civil liability arising from a criminal offense. Metropolitan Bank and Trust Company versus Tonda. Rights of the entrustor. What are the rights of an entrustor? To be entitled to the proceeds of the sale of the goods under trust receipt to the extent of the amount owing to him or to return the goods in case of non-sale. To cancel the trust and take possession of the goods or of the proceeds realized therefrom at any time upon default of the entrustee. To sell the goods with at least 5-day notice to the entrustee and apply the proceeds in payment of the obligation. Entrustee is liable to pay deficiency, if any. Validity of the security interest as against creditors of the entrustee, innocent purchaser for value. As between the entrustor and the creditors of the entrustee, who has the better right over the goods? The entrustor. His security interest in goods, documents, or instruments pursuant to the written terms of a trust receipt shall be valid as against all creditors of the entrustee for the duration of the trust receipt agreement. Who can defeat the rights of the entrustor over the goods? A purchaser in good faith. He acquires goods, documents, or instruments free from the entrustor's security interest. Goods covered by the trust receipt not subject to levy. Are the goods covered by the trust receipt subject to levy? General rule: no. The law warrants the validity of entrustor's security interest as against creditors of the trust receipt agreement during the duration of the trust receipt agreement. Exception: when the properties are in the hands of an innocent purchaser for value and in good faith. Prudential Bank versus NLRC. Obligations or liability of the entrustee. What are the obligations and liabilities of the entrustee? To hold good, documents, and instruments in trust for the entrustor and to dispose of them strictly in accordance with the terms of the trust receipt. Number 2. To receive the proceeds of the sale for the entrustor and to turn over the same to the entrustor to the extent of amount owing to the entrustor. 3. To insure GDI against loss from fire, theft, pilferage, or other casualties. GDI is good, document, and instrument. To keep GDI or the proceeds thereof, whether in money or whatever form, separate and capable of identification as property of the entrustor. To return GDI to the entrustor in case they could not be sold or upon demand, or the entrustor. And number 6, to observe all other conditions of the trust receipts. GDI is good, documents, and instruments. Order for application of proceeds. What is the order in the application of proceeds of the trust receipt transaction? Expenses of the sale. 2. Expenses derived from storing the goods. 3. Principal obligation. Is the entrustee liable for the deficiency? Yes, but any excess shall likewise belong to him. Liability for goods. For loss of goods, documents, or instruments. GDI. Who shall bear the loss of goods which are the subject of trust receipt? The entrustee. Loss of goods, documents, or instruments which are the subject of a trust receipt, pending their disposition, irrespective of whether or not it was due to the fault or negligence of the entrustee, shall not extinguish his obligation to the entruster for the value thereof. Section 10, PD 115. Note: the principle of res perit domino will not apply against the entruster. Res perit domino means the thing is lost to the owner. This phrase is used to express that when a thing is lost or destroyed, it is lost to the person who was the owner of it at that time. Remedies. What are the remedies available to the entruster? File a criminal action for estafa in case of failure of the entrustee to deliver the proceeds of the sale of the goods under the trust receipt up to the extent of his obligation to the entruster. Note: the civil action may be instituted in the criminal action, separately filed independently of the criminal action. Criminal action based on ex delito, civil action based on ex contracto. 2. Cancel the trust and take possession of the goods at any time upon default of the entrustee. 3. After the repossession, the entruster may sell the goods upon at least 5-day notice to the entrustee and apply the proceeds in payment of the obligation. The entrustee is liable for the deficiency or entitled to excess, if any. 4. If a surety secures the obligation of the entrustee, in addition to the trust receipt, the law does not obligate the entruster to cancel the trust or take possession of the goods. He can proceed against the surety. The options belong to the entruster. In the event of default, it is mandatory or compulsory for the entruster to cancel the trust and take possession of the goods to be able to enforce his rights. No, the law uses the word may in granting to the entruster the right to cancel the trust and take possession of the goods. Thus, he has the discretion to avail itself of such right to sue or seek alternative actions, such as third-party claim or a separate civil action, which it deems best to protect its right, at any time upon default or failure of the entrustee to comply with any of the terms and conditions of the agreement. South City Homes versus BA Finance Corporation. Chattel mortgage. What is a chattel mortgage? An accessory contract whereby a person property is recorded in the chattel mortgage register to secure the performance of a principal obligation. Note: the concept of a chattel mortgage as a conditioned sale under the old chattel mortgage law has been supplanted by the definition of chattel mortgage under Article 2140 of the Civil Code. It is now an accessory contract, no longer a conditional sale. Characteristics of chattel mortgage. An accessory contract because it is for the purpose of securing the performance of a principal obligation. A formal contract because of its enforceability. Registration in the chattel mortgage register is indispensable. Unilateral contract because it produces only obligation on the part of the creditor to free the thing from encumbrance on the fulfillment of the obligation. Note: the extinguishment of the accessory contract does not extinguish the principal contract. The extinguishment of the principal contract extinguishes the accessory contract. Essential requisites. What are the essential requisites of a valid chattel mortgage? 1. Constituted a secure fulfillment of the principal obligation. 2. Mortgager is the absolute owner of the property. 3. Mortgager has free disposal of the property in the absence thereof, that he be legally authorized for such purpose, that it involves the personal property. Section 2085 of the New Civil Code. Formal requisites. What are the formal requisites for a valid chattel mortgage? Affidavit of good faith. Registration with the chattel mortgage registry. 3. If necessary, additional registration with a proper government agency. Affidavit of good faith. What is the affidavit of good faith? A certificate included in the chattel mortgage contract executed by mortgager and the mortgagee stating that the obligation is valid, just, and subsisting, and it is not one entered into for purposes of fraud. What is the effect of absence of affidavit of good faith? It does not affect the validity of the chattel mortgage, but the same will be unenforceable against third persons. What is the status of an unrecorded chattel mortgage? The mortgage is valid and binding between the parties. Registration is necessary only for the purpose of binding third persons. Note, in an action for collection, the non-registration of the chattel mortgage, which ordinarily does not bind third persons, is not critical. The rule is different when the remedy resorted to is foreclosure. What is the effect if the mortgage is not registered? It is nevertheless binding between the parties. What is the period within which the registration should be made? The law does not provide any specific time, yet the law is substantially and sufficiently complied with where the registration is made by the mortgagee before the mortgager has complied with his principal obligation and no right of innocent third persons is prejudiced. What is the effect of registration? It creates real right. It is an effective and binding notice to the other creditors of its existence and creates a real right or lien which follows the chattel whatever it goes. The registration gives the mortgagee symbolical possession. The efficacy of the act of recording a chattel mortgage consists in the fact that it operates as a constructive notice to the existence of the contract. Explain the dual registration rule. The property must be registered, place where the mortgager resides, in the place where the property is situated. Exception, if the mortgager resides in the same place where the property is located, or if the amount of the loan is more than 500,000, registration should be made in the city or municipality where the property is situated. PD 1159, Section 113 and 114. Rules. Private vehicle. Private motor vehicle, Land Transportation Office LTO, Public Motor Vehicle, Land Transportation Franchise and Regulatory Board LTFRB, Vessels, Maritime Industry Authority, Marina, Aircraft, Civil Aviation Authority of the Philippines, CAAP, Chattel Mortgage versus Pledge. Distinguish chattel mortgage from pledge. Chattel mortgage. Under delivery, delivery is not necessary. Registration in the chattel mortgage register is necessary for its enforceability. Cannot secure future obligations. Procedure for the sale of the thing given as security is governed by Section 14, Act Number 1508. If the property is foreclosed, the excess goes to the debtor. The creditor is entitled to recover the deficiency from the debtor except if the chattel mortgage is a security for the purchase of property in installment. Under pledge, delivery is necessary. Registration in the registry property is not necessary. Can secure future obligations. Law governing the sale of pledge, Article 212, NCC. Excess. If the property is sold, the debtor is not entitled to the excess unless otherwise agreed. The creditor is not entitled to recover the deficiency notwithstanding any stipulation to the contrary, that is under pledge. Possession. Under chattel mortgage, possession remains with the debtor. Under contract, formal contract. Recording in a public instrument must be recorded in a public instrument to by third person. Under pledge, possession is vested in the creditor. Contract of pledge is real contract. Recording in a public instrument under pledge must be in the public instrument containing description of the thing pledged and the date thereof to bind third persons. Subject matter of chattel mortgage. What is the subject matter of chattel mortgage? It must always be personal or movable property. What are the properties mortgageable under the law? 1. Shares of stock. In corporation, if the owner of the share is not domiciled in the same province where the corporation is domiciled, the registration must be made in both provinces. Number 2. An interest in business for its personal property capable of appropriation. 3. Machinery treated by the parties as personal property subsequently installed or leased land, on leased land. 4. vessels, but it is essential that the mortgage is recorded in the office of the Marina Maritime Industry Authority to be effective as the third person. It is not necessary that it be recorded in the office of the Register of Deeds. Motor vehicles must be registered with the Land Transportation Commission, and with respective vehicles used for public services, it must also be approved by the Public Service Commission LTFRB. 6. House of mixed materials. 7. House intended to be demolished, for what are really mortgaged in this case are the materials thereof. 8. House built on rented land, since it did not form part of the land. It is settled that an object placed on land by one who had only a temporary right to it does not become immobilized by attachment. 9. A house of strong materials, as long as the parties to the contract so agree, and no innocent third party will be prejudiced thereby. What is the effect if a chattel mortgage is constituted on machinery permanently attached to the ground? It is to be considered as personal property, and the chattel mortgage constituted thereon is null and void, regardless of who owns the land. However, the chattel mortgage is binding on the contracting parties but cannot prejudice innocent third parties. Makati Leasing and Finance Corp. versus Wherever Textile Miles. In accordance with Article 2125 of the Civil Code, an unregistered chattel mortgage is valid and binding between the parties because registration is necessary only for the purpose of binding third persons. Filipinas Marble Corp. versus IAC. What is the appropriate remedy to unvolve the machinery preparatory to the extrajudicial foreclosure? 1. Action for replevin preparatory to extrajudicial foreclosure. 2. Simply judicially foreclose. Mortgagee versus innocent purchaser for value. In one case, the court held that chattel mortgage over a house is valid between the contracting parties, even though it is a real property. Since it is valid mortgage, the mortgagee can foreclose in case of default. But even if he has foreclosed the chattel mortgage, it does not bind the judgment creditor of D because it does not affect innocent third parties. The conclusion will not change even if the mortgagee sold the house to the third party, an innocent purchaser for value. The innocent purchaser for value has a right inferior compared to the rights of the judgment creditors of D, for the simple reason that the innocent purchaser for value simply steps into the shoes of the original mortgagee and acquires only whatever rights, title, or interest that the mortgagee originally had over the house, and subject to the same limitations. If the right of the original mortgagee is enforceable only against the mortgager, the right of the innocent purchaser for value, the assignee of the original mortgagee, is also valid and enforceable only against the mortgager, but that does not prejudice or affect innocent third parties like judgment creditors of the mortgager. After acquired property. Can the chattel mortgage cover after acquired properties? General rule, no, because Section 7 of Act 1508 provides a chattel mortgage shall be deemed to cover only the property described therein, and not like or substituted property thereafter acquired by the mortgager and placed in the same depository as the property originally mortgaged. Exception where the after acquired property is in renewal of or in substitution for goods on hand when the mortgage was executed or is purchased with the proceeds of the sale of such goods. Note, while pledge, real estate mortgage, or anti-crisis may secure after incurred obligations so long as these future debts are accurately described, a chattel mortgage can only cover obligations existing at the time the mortgage is constituted. Although the promise expressed in the chattel mortgage to include debts that are yet to be contracted can be a binding commitment that can be compelled upon, the security itself, however, does not come into existence or arise until after a chattel mortgage agreement covering the newly contracted debts is executed, either by concluding a fresh chattel mortgage or by amending the old contract conformably with the form prescribed by the chattel mortgage law. Does the law require a minute and specific description of every chattel mortgage in the deed of mortgage? No. It only requires that the description of the mortgage property be such as to enable the parties to the mortgage or any other person to identify the same after a reasonable investigation and inquiry. after incurred obligation. No, the affidavit of good faith in a chattel mortgage makes it obvious that the debt referred to in the law is current, not an obligation that is yet merely contemplated. Acme Shu versus CA. What then is the consequence of a chattel mortgage covering after incurred obligations? A promise expressed in a chattel mortgage to include debts that are yet to be contracted can be a binding commitment that can be compelled upon. The security itself, however, does not come into existence or arise until after a chattel mortgage agreement covering newly contracted debts is executed, either by concluding a fresh chattel mortgage or by amending the old contract conformably with the form prescribed by the chattel mortgage law. The remedy of foreclosure can only cover the debts extant at the time of constitution and during the life of the chattel mortgage sought to be foreclosed. Dragnet clause. What is a dragnet clause? It is a clause which operates as a convenience and accommodation to the borrowers as it makes available additional funds without their having to execute additional security documents, thereby saving time, travel, loan closing, cost of extra legal services, recording fees, etc. It subsumes all debts of past or future origin. How do you construe such clause? It must be carefully scrutinized and strictly construed, particularly where the mortgage contract is one of adhesion. Note, a mortgage given to secure future advancement is a continuing security and is not discharged by the repayment of the amount named in the mortgage until the full amount of the advancement is paid. It permitted the mortgagor to take the money as it is needed and thus avoid the necessity of paying interest until the necessity for its use actually arises. Remedies available in case of simple loan. What does the word default cover? Non-payment, violation of the terms of the agreement. What is the effect of stipulation prohibiting the mortgagor from exercising acts of ownership? Such agreement is void, since the mortgagor remains the owner of the chattel. He can sell it even if the chattel mortgage agreement prohibits the mortgagor from selling the chattel without the consent of the mortgagee. The sale, however, is without prejudice to his criminal prosecution under the permanent provisions of the RPC. The sale can be considered as violation of the terms of the chattel mortgage. What are the remedies in case of default? Action for collection. 2. Foreclosure. Note, there is no rescission in case of simple loan. What is the nature of these remedies? They are alternative remedies. The election of one bars the other remedies. The mere filing of the collection case bars the foreclosure, regardless of the venue, whether here or abroad. Foreclosure. What is foreclosure? It is the remedy available to the mortgagee by which he subjects the mortgaged property to the satisfaction of the obligation to secure which the mortgage was given through the sale of the property at public auction and the application of the proceeds thereof to the payment of his claim. State the essence of a contract of mortgage. The essence of contract of mortgage indebtedness is that a property has been identified or set apart from the mass of the property of the debtor mortgagor as security for the payment of money or the fulfillment of an obligation to answer the amount of indebtedness in case of default of payment. What are the kinds of foreclosure? Judicial foreclosure, extrajudicial foreclosure. Judicial foreclosure, by bringing an action for that purpose in the RTC of the province or city where the real property or any part thereof lies, the proceeds of the sale shall be applied to the payment of the A. Costs of the sale. B. Amount due to the mortgagee. C. Claims of persons holding subsequent mortgages in the order of their priority. And D. Balance, if any, shall be paid to the mortgagor. Extrajudicial foreclosure. A mortgage may be foreclosed extrajudicially where there is inserted in the contract a clause giving the mortgagee the power upon default of the debtor to foreclose the mortgage and extrajudicial sale of the mortgage property. What is the remedy if the mortgagee cannot obtain possession of mortgage property? If a mortgagee cannot obtain possession of a mortgage property for its sale on foreclosure, the mortgagee cannot take the property by force but must institute the appropriate action in the court. He must bring a civil action for replevin either to recover such possession or, as preliminary step, on the extrajudicial foreclosure of the chattel mortgage, or judicial foreclosure. Note, foreclosure can be public sale, private sale, if stipulated by the parties. Two-bidder rule. What is a so-called two-bidder rule? There must be at least two participating bidders for the auction sale to be valid. Does the two-bidder rule apply to chattel mortgage? No, it only applies to pledge. Twin period rule. What is the twin periods rule? In case of the equity of redemption, the mortgagor has the right to prevent the sale by paying the debt within 30 days from default. So it is a grace period that the law affords in favor of the mortgagor. Within 30 days grace period, there must be a notice of sale given to the mortgagor. Also, there must be a 10-day notice to the mortgagor prior to the sale. Claim of deficiency. Can the mortgagee claim in case of deficiency? General rule, yes. Mortgagee is entitled to recover deficiency, exception, contrary stipulation, transactions covered by recto law, Article 1484 NCC. 3. In accommodation mortgages, the accommodation mortgagor is liable only to the extent of the value of the mortgage property. 4. Due to death of mortgagor. In case of pledge, is a stipulation to recover deficiency valid? No, it is void. Does the claim for deficiency prescribe? A mortgage action prescribes in 10 years from the time the right of action accrues. That is, from the time the mortgagor defaults in the payment of his obligation to the mortgagee and not from the date of the execution of the mortgage contract. Accommodation mortgagor. What is an accommodation party? He is a person who has signed the instrument as maker, drawer, acceptor, or endorser without receiving value there. 4. And for the purpose of lending his name to some other persons, he is liable on the instrument notwithstanding that such holder at the time of taking the instrument knew such person to be only an accommodation party. The accommodation party has right, after paying the holder, to obtain reimbursement from the party accommodated, since the relation between them is in effect that of principal and surety, the accommodation party being the surety. Note, ordinarily, the debtor is also the mortgagor, but it is also possible that a third party may constitute a mortgage in favor of the mortgagor. This arrangement is valid even if the accommodating party does not receive anything. What is the extent of the liability of the accommodation mortgagor? His liability is limited only to the value of the property he secured for another. Death of mortgagor. What is the remedy in case of death of mortgagor? File a money claim against the estate, whether real property or personal property. If the mortgagee closed this remedy, he is deemed to have abandoned the mortgage and he lost priority. To foreclose, number 2, to foreclose the mortgage by ordinary action in court and recover any deficiency against the estate in administration, and to foreclose without action at any time within the period allowed by the statute of limitation. Transactions covered by recto law, Articles 1484 and 1485 of the Civil Code. Article 1484. In a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. 1. Exact fulfillment of the obligation should the vendee fail to pay. 2. Cancel the sale should the vendee's failure to pay cover 2 or more installments. 3. Foreclose the chattel mortgage on the thing sold if one has been constituted should the vendee's failure to pay cover 2 or more installments. In this case, he shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. When does the recto law apply? Sale of personal property, the price of which is payable in 2 or more installments. 2. Contracts purporting to be leases of personal property with option to buy, Article 1485. What are the requisites of the sale to be covered under the recto law? Sale of personal property. 2. Payable in installments. 3. Chattel mortgage constituted over the same property. Under the recto law, what are the remedies of the unpaid seller? Exact fulfillment of the obligation should the vendee fail to pay, action for specific performance. 2. Cancel the sale should the vendee's failure to pay cover 2 or more installments. It's rescission. Or number 3, foreclose the chattel mortgage on the thing sold should the vendee's failure to pay cover 2 or more installments. Can the unpaid seller avail of all remedies? No. The remedies are alternative. The three remedies under this article available to the vendor who has sold personal property on the installment plan are alternative, not cumulative. In other words, if the vendor has selected to avail himself of any of the remedies, he is deemed to have renounced the others. Tolentino, Volume 5. What is the reason for this rule? According to Senator Tolentino, in case the vendor elects to foreclose the mortgage, if one has been given on the property, he is not obliged to return to the purchaser the amount of the installment already paid, should there be an agreement to that effect, and it is not unconscionable. Note, in all proceedings for the foreclosure of chattel mortgages executed on the chattels, which have been sold on the installment plan, the mortgagee is limited to the property only in the mortgage. Thus, the principal object of Article 1484 was to remedy the abuses committed in connection with the foreclosure of chattel mortgages. This prevents mortgagees from seizing the engaged property, buying it at foreclosure for a low price, and then bringing suit against the mortgagor for the deficiency judgment. The almost invariable result of this procedure was that the mortgagor found himself minus the property and still owing practically the full amount of the original indebtedness. Note, according to Dean Davina, the reason for this rule is to encourage the mortgagee creditor to make a reasonable bid. If he bids at a low price, the company will recover on its book of accounts the deficiency as a loss. To prevent this situation, the mortgagee will bid at a reasonable amount. Article 1484, not applicable in case mortgagee is not the vendor. Thus, Article 1484 applies against a mortgagee who is not a vendor of the chattel mortgage. Article 1484 of the new Civil Code does not apply as against a mortgagee who is not a vendor of the chattel mortgage. Thus, a suit for replevin is not equivalent to an exercise of the remedy of foreclosure under Article 1484 of the new Civil Code. Hence, the vendor mortgagee is not barred from making a claim for specific performance against the buyer mortgagor by the mere fact that the former was already able to secure a rate of replevin. Rescission. Note, in rescission there should be mutual restitution, except in case of stipulation of forfeiture of prior payments. Replevin. What is replevin? It is the appropriate action to recover possession, preliminary to the extrajudicial foreclosure of a chattel mortgage. Who can institute replevin suit? It is not only the owner but also a person entitled to the possession of the property can institute a replevin suit. In case of recovery of property through replevin preparatory to foreclosure, is it a bar to avail of other remedies? Recovery of property through a replevin case preparatory to foreclosure will not bar the other remedies if there was no actual foreclosure. If seller mortgagee opts to file an action for specific performance, he shall be deemed to have waived his rights as a mortgagee, but may still levy on the mortgage property on execution. Replevin, voluntary, not akin to foreclosure. Example, surrender of the property. Not a bar to avail of other remedies, exception if possession is in view of dación en pago. Involuntary, akin to foreclosure, a bar to other remedies which are alternative. Dación en pago is a Spanish term that means that giving back of the property mortgage to the lender in exchange for the discharge of a mortgage debt. This procedure is usually resorted to by borrowers who cannot anymore meet their mounting obligations on the mortgage. Is the mortgagee's letter informing the mortgagor of his intent to foreclose already considered a foreclosure of the chattel? No. A mere offer by the mortgagor to surrender the chattel, not accepted by the mortgagee, does not preclude the mortgagee from bringing suit to recover the balance of the purchase price. Is mere demand sufficient to foreclose the object? A mere demand to surrender the object which is not heeded by the mortgagor will not amount to foreclosure, but the repossession thereof by the vendor mortgagee would have the effect of foreclosure. Bourbon II versus Service-Wide Specialist. Is a mortgagee of a personal property sold on installments after taking possession of the property legally obligated to foreclose the chattel mortgage and sell it at public auction? Having opted to foreclose the chattel mortgage, GAMI can no longer cancel the sale. The three remedies of the vendor in case the vendee defaults: in contract of sale of personal property, the price of which is payable in installment under Article 1484 of the Civil Code, all are alternative and cannot be exercised simultaneously or cumulatively by the vendor creditor. Esguerra versus CA. What are included in the term debt, which are extinguished under direct to law: principal, interest, cost of collection. Who bears the necessary expenses incurred in the prosecution of by the mortgagee of the action for replevin to regain possession of the chattel? It is the mortgagor who bears such expenses. What does recoverable expense include? It includes expenses properly incurred in effecting seizure of the chattel and reasonable attorney's fees in prosecuting the action for replevin. Augustine versus CA. Note, the cost of repossession, which is brought by the unjustified refusal of the mortgagor, can still be recovered and is not deemed extinguished. Additional security. What is the effect of the foreclosure as regards the personal property which are not subject of the sale but are given as additional security? Under Article 1484 of the NCC, the vendor of personal property sold on installment who chooses the remedy of foreclosure of the chattel mortgage is limited to the foreclosure of the item sold only and not to the other items not subject to the sale, although also given as additional security. The foreclosure of the latter is null and void. Redad versus Filipinas Investment and Finance Corporation. All other additional securities are barred once the mortgagee chose to foreclose. This also bars him from going against the surety or guarantor. Redad versus Filipinas Investment and Finance Corporation. Having chosen to foreclose the chattel mortgage and brought the purchased vehicles at the public auction as the highest bidder, it submitted itself to the consequences of the law as specifically mentioned, by which it is deemed to have renounced any and all rights which it might otherwise have under the promissory note and the chattel mortgage, as well as the payment of the unpaid balance. Under the law, should the vendor choose to foreclose the mortgage, he has to content himself with the proceeds of the sale at the public auction of the chattels which were sold on installment and mortgaged to him, and having chosen the remedy of foreclosure, he cannot nor should he be allowed to insist on the sale of the house and lot of the vendees, for to do so would be equivalent to obtaining a writ of execution against them concerning other properties which are separate and distinct from those which were sold on installment. This would indeed be contrary to public policy and the very spirit and purpose of the law, limiting the vendor's right to foreclose the chattel mortgage only on the thing sold. Simple loan versus rec to law. Simple loan. The taking of possession by replevin is not equivalent to foreclosure. Remedies: foreclosure, action for specific performance. Suggested remedy: foreclose. Don't even think about it because you have a lien in such case. Recovery of deficiency: you can recover for deficiency, and the right to recover deficiency may be enforced against any one of the solidary co-debtors, if any, and is not limited to the mortgagor, for the reason that the chattel mortgage is just a security, not a mode of payment. Effect of election of action for collection. Election of action for collection is a bar to the other remedy. Rec to law. The taking of possession by replevin is tantamount to foreclosure, which bars the action for specific performance. Remedies: action for specific performance, cancellation of rescission, or foreclosed or chattel mortgage on the thing sold. Suggested remedy: weigh the options. Recovery of deficiency precludes the mortgagee to recover the deficiency. Effect of election of action for collection: if it is a transaction falling under direct law, it is only the mortgagee actually foreclose or elects the remedy of foreclosure that he is subject to the rule that he cannot recover any unpaid claims. So if he files an action for collection and obtain judgment, then he can levy any and all properties of the mortgagor until the debt is paid or satisfied. Note, in case of transactions under the rec to law, it is only when there has been a foreclosure of the chattel mortgage that the vendee mortgagor would be permitted to escape from deficiency liability. Hence, if the case is one of the specific performance, even when this action is selected after the vendee has refused to surrender the mortgage property to permit an extrajudicial foreclosure, the property may still be levied on execution. Equity of redemption. Is there a right of redemption in case of personal properties? None. When is equity of redemption may be exercised? Equity of redemption may be exercised by the mortgagor after his default in the performance of his obligation, but before the sale of the mortgage property or confirmation of sale. When is the right of redemption available? The Supreme Court said that there are only three cases where there is a right of redemption, and they do not involve personal property. They only pertain to real property. There are only three. 1. Extrajudicial foreclosure of the real estate mortgage under Article 3135. Execution sale of a real property under the Rule 39 of the Rules of Court. Judicial foreclosure of a real estate mortgage if the mortgagee is a bank or a credit institution. Note, so the mortgagee cannot foreclose right away after default. He has to give the mortgagor 30 days grace period. That is what you call equity of redemption. The right of the mortgagor to prevent the sale by paying the debt within 30 days from default. It is only if he failed to pay the debt that there can be actual foreclosure of chattel mortgage. Banking laws. General Banking Act. Bank. What are banks? Entities engaged in the lending of funds obtained through deposits from public. Elements. What are the elements determinative of a bank? Must be authorized by law. Accepts funds in the form of a deposit from the public and there are at least 20 depositors. Lends money to public. Note, the fourth element under the old code habitually has been deleted. Is a transaction involving purchase of receivables considered as banking transaction? If it is a transaction not involving a loan but purchase of receivables at a discount, it is well within the purview of investing, reinvesting, or trading in securities, which an investment company is authorized to perform and does not constitute a violation of the General Banking Act. This transaction is known as a deposit substitute. Note, what is prohibited by law is for investment companies to lend funds obtained from the public through receipts of deposit, which is a function of banking institution, but here the funds supposedly lent to petitioners have not been shown to have been obtained from the public by way of deposits, hence the inapplicability of banking laws. Banyas versus Asia Pacific Finance. Paluwagan. Describe the concept of paluwagan. Even if there are more than 20 members, such is not considered as a bank. The funds are not obtained in the form of deposit. It is for saving among its members. Deposit-taking activity. What is a deposit-taking activity? The funds given to the bank gives rise to creditor-debtor relationship. The ownership of the funds is thus transferred to the banks, and the latter are free to use the funds as it pleases. Deposit substitute. What are deposit substitutes? It is an alternative form of obtaining funds from the public other than deposits through the issuance, endorsement, or acceptance of debt instrument or the borrower's own account for the purpose of relending or repurchasing of receivables and other obligations. These instruments may include, but need not be limited to, bankers' acceptance, promissory notes, participations, certificates of assignment, and similar instruments with recourse and repurchase agreements. Quasi-banks. These are entities engaged in the borrowing of funds through the issuance, endorsement, or assignment with recourse or acceptance of deposit substitutes for purposes of relending or purchasing of receivables and other obligations. Note, quasi-banks are also under BSP. They have to secure a license from BSP. Banks versus quasi-banks. Banks obtains funds from the public in the form of deposit. Quasi-banks refer to entities engaged in the borrowing of funds through the issuance, endorsement, or assignment with recourse of acceptance of deposit substitutes for purposes of relending or purchasing of receivables and other obligations. Banks. Deposits are insured with PDIC. Quasi-banks, not insured with PDIC. Banks. There is creditor-debtor relationship. Quasi-banks, no creditor-debtor relationships. Co-warrantor proceedings. What is the appropriate proceeding to question a corporation who performs function of a bank without the license from BSP? Any corporation who does these functions and activities without a corresponding license or approval from the SEC can be ousted by way of quo warranto proceedings, Republic of the Philippines versus Security Credit and Acceptance. Classification of banks. Universal banks can exercise the powers of an investment house and invest in non-allied enterprises and have the highest capitalization requirement. Capital 4.950 billion. Commercial banks. Ordinary banks governed by the GBL, which have a lower capitalization requirement than universal banks and can neither exercise the powers of an investment house nor invest in non-allied enterprise. Capital 2.4 billion. Thrift banks. These are savings and mortgage banks, stock savings and loan associations, private development banks, which are primarily governed by the Thrift Banks Act or RA 7906, rural banks, cooperative banks, Islamic banks, other classification of banks as determined by the Monetary Board of Bangko Sentral ng Pilipinas. Bank power and liabilities. Universal bank. Power of a commercial bank. B. Power of an investment house. C. Power to invest in the equities of allied enterprise. D. Power to invest in the equities of non-allied enterprise. Commercial bank. General power incident to a corporation. B. All such powers as may be necessary to carry on the business of commercial banking such as ADD, EBC, or accepting draft and issuing LCs. 2. Discounting and negotiating promissory notes, draft bills of exchange, and other evidence of indebtedness. 3. Accepting or creating demand deposits. 4. Receiving other types of deposits and deposit substitute. 5. Buying and selling foreign exchange and gold or silver bullion. 6. Acquiring marketable bonds and other debts, securities, and extending credit. C. Power to invest in the equities of allied enterprise. Note, whatever a commercial bank can do, a universal bank can also perform. Allied and non-allied transactions. What do you mean by invest in equity? It means to be a stockholder of another corporation, whether allied or related undertakings. Any undertaking which is about money such as foreign exchange, leasing, investment company, insurance company, warehousing. Note, an example of non-allied undertaking is cargo operation. What are the kinds of underwriting agreement? Firm commitment, those which are considered as sold. Best effort. Underwriter does not guarantee that it will sell the entire what? The underwriter purchases outright the security and then resell the same. Firm commitment. Best effort, the underwriter merely sells for commission. Banking and incidental powers. What are the other services that a bank may offer? 1. Receive in custody funds, documents, and other valuable objects. 2. Act as financial agent and buy and sell for the account securities. 3. Make collection and payments for the account of others. 4. Perform such other services not incompatible with banking business. And 5. Upon prior approval of the BSP, act as manager, advisor, investment management accounts. 6. Rent out safety deposit box. Is safety deposit box a form of deposit or lease? The contract for the use of a safe deposit box should be governed by the law on lease. Under the old banking law, a safety deposit box is a special deposit. However, the new general banking law, while retaining the renting of a safe deposit box as one of the services that the bank may render, deleted reference to depository function. SIA versus Court of Appeals. Justice Edgardo Perez was of the opinion that the contract for the use of safety deposit box is governed by the law on lease. The Supreme Court did not agree with him and said that contract for the use of safety deposit box is a special kind of deposit. In other words, the bank must exercise the due diligence required of depository in safekeeping or preserving of the object inside the safety deposit box. The basis for this is that under the old General Banking Act, it provided that in renting out safety deposit boxes, the bank shall act as depositary. Because the law itself provided for this, Supreme Court concluded that the contract for the use of safety deposit box is governed by deposits. New law retains the authority of the bank to rent out safety deposit box but silent on being a depositary. Power to acquire real properties. Can the bank acquire real property in settlement of a civil liability arising from a crime? Generally, no. Exceptions. It can only acquire real property when A. It is needed for business. B. As shall be conveyed to it in satisfaction of debts previously contracted in the course of its dealing, dación en pago. C. As shall be mortgaged to it in good faith by way of security of debts, foreclosure. D. As it shall purchase at sales under judgments, decrees, or gages, or trust deeds, execution sale to satisfy judgment. Note, any property acquired under B and D, B to D, should be disposed of within 5 years from the acquisition because the bank is not a realty company. Q. Can banks acquire ownership of real property by virtue of the deed of transfer executed by its former employee in satisfaction of a civil liability arising from the criminal offense? Answer. A bank cannot acquire ownership of real property by virtue of the deed of transfer executed by its former employee in satisfaction of a civil liability arising from the criminal offense, since debts referred to in the law are only those resulting from previous loans and similar transactions made or entered into by a bank in the ordinary course of its business. Diligence required of banks. What is the degree of diligence required of banks in handling deposits? Extraordinary diligence. The appropriate standard of diligence must be very high, if not the highest degree of diligence. Highest degree of care. BCI Bank versus CA. Does the bank need to exercise extraordinary diligence in all commercial transactions? No. The degree of diligence required of banks is more than that of a good father of the family, where the fiduciary nature of their relationship with their depositors is concerned. That is, depositary of deposits. But the same higher degree of diligence is not expected to be exerted by banks in commercial transactions that do not involve their fiduciary relationship with their depositors, such as sale and issuance of foreign exchange demand draft. Reyes versus CA. In what transactions this highest degree of care of diligence is applied? This applies only to cases where the banks are acting in their fiduciary capacity, that is, a depository of the deposits of their depositors. Reyes versus CA. Note, the General Banking Law of 2000 requires banks the highest degree of standards of integrity and performance. Hence, a bank is under obligation to treat the accounts of its depositors with meticulous care. Philippine Savings Bank versus Chowking Food Corporation. What is the effect when the teller gave the passbook to a wrong person? If the teller gives the passbook to the wrong person, they would be clothing the person presumptive ownership of the passbook, facilitating unauthorized withdrawals by that person. For failing to return the passbook to authorized representative of the depositor, the bank presumptively failed to observe such high degree of diligence in safeguarding the passbook and ensuring its return to the party authorized to receive the same. The bank's liability, however, is mitigated by the depositor's contributory negligence in allowing a withdrawal slip signed by authorized signatories to fall into the hands of an impostor. Consolidated Bank and Trust Company versus CA. Did a bank exercise diligence required when the pre-termination of the account is allowed despite discrepancies in the signature and photographs of the person claiming to be the depositor and failure to surrender the original certificate of time deposit? No. The bank is negligent because the depositor did not present the certificate of deposit. Is the bank liable when an employee encashes a check without the requisite of endorsement? Yes. The fiduciary nature of the relationship between the bank and the depositors must always be of paramount concern. Philippine Savings Bank versus Chowking. Note, in a checking transaction, the drawee bank has a duty to verify the genuineness of the signature of the drawer and to pay the check strictly in accordance with the drawer's instruction to the named payee in the check. Otherwise, the drawee will be violating the instructions of the drawer, and it shall be liable for the amount charged to the drawer's account. The drawee bank had the responsibility to ascertain the regularity of the endorsements and the genuineness of the signatures of the checks before accepting them for deposit. Thus, banks are minded to treat their customers' accounts with utmost care, confidence, and dishonesty. PNB versus Rodriguez. Nature of bank funds and bank deposits. What law governs bank deposits? The law on loans. Creditor and debtor relationship is created between the bank and the depositors. What is the nature of a bank deposit? All kinds of bank deposits are loan. The bank can make use of it as its own the money deposited. Said amount is not being held in trust for the depositor, nor is it being kept for safekeeping. Bank, not a trustee. Is bank a trustee? No. The fiduciary nature of a bank-depositor relationship does not convert the contract between the bank and its depositors from a simple loan to trust agreement. Failure by the bank to pay the depositor is failure to pay a simple loan, and not a breach of trust. Mandamus will not lie. In the enforcement of obligations concerning deposit, will the remedy of mandamus lie? No, because all kinds of deposits are loan. Thus, the relationship being contractual in nature, mandamus cannot be availed of because mandamus will not lie to enforce the performance of contractual obligations. After procuring a checking account, the depositor issued several checks. He was surprised to learn later that they had been dishonored for insufficient funds. Investigation disclosed that deposits made by the depositor were not credited to its account. Is the bank liable for damages? Yes. The depositor expects the bank to treat his account with utmost fidelity, whether such account consists only a few hundred pesos or of millions. The bank must record every single transaction accurately, down to the last centavo, and as promptly as possible. This has to be done if the account is to reflect at any given time the amount of money the depositor can dispose of as he sees fit, confident that the bank will deliver it as and to whomever he directs. A blunder on the part of the bank, such as this owner of the check without good reason, can cause the depositor not a little embarrassment, if not also financial loss and perhaps even civil and criminal litigation.